Okay. Um, Good afternoon. We'll go on the record now. The time is just about 1 o'clock on February 27th, 2025. This is the hearing for Deschutes County file number 2472400. That's 30753-AD, which is a request by the applicant for land use approval for a replacement dwelling in the forest use zone and wildlife area combining zone. My name is Greg Frank, and I am the hearings officer who has been assigned to this matter. We'll talk about whether or not I will continue shortly, but I have been assigned. Um, Before we turn to the particulars of the hearing, though, I would like to turn things over to Ms. House to describe how the participation process will work, so each and every one of you will have an opportunity to speak if you so desire. Ms. House?
All right. Good afternoon. For the record, my name is Caroline House, and I'm a senior planner with the Deschutes County Planning Division. I'll start the hearing by going over how the hearing will be conducted today, and then I'll have a brief staff presentation. Then we'll move on to the testimony portion of the hearing. The applicant will have 30 minutes, then persons in support will have 3 minutes, then persons in opposition will have 3 minutes as well. The applicant then gets 10 minutes for rebuttal, and lastly, staff can provide closing comments. And I will note that the hearings officer can eliminate or modify time limits at his discretion. Today's hearing is a hybrid hearing, so both in-person and remote participation is allowed. Before starting your testimony, regardless of how you're attending, please state your first and last name and provide your mailing address. For our in-person participants, hearings officer Frank will call you up to the front of the room to provide your testimony. Please make sure you're seated at the table so your audio can be picked up so he can hear you and anyone else can hear you. And if you haven't already, please write your name and contact information on the sign-in sheet. For anyone attending remotely, you need to be logged in using Zoom to testify. And hearings officer Frank will request that you use the raise hand feature to notify him that you would like to testify. If you're on a computer or a smartphone, you'll need to press the raise hand button. That will be in the bottom center part of your screen. And if you've dialed in, you'll need to dial *9. In addition to oral testimony, you can submit written testimony today. If you're in person, please hand me your written testimony after you've provided your oral testimony. And if you're attending remotely, you'll need to email me any written submittals. My email is caroline.house@deschutes.org. Hearings officer Frank and staff are responsible for a respectful and orderly hearing. Anyone being disruptive may be asked to leave. And I'm going to pause now and ask if there are any objections to this hearing format. Any raised hands online? All right, so I'll turn it back over to you, hearings officer Frank.
Thank you. As Ms. House described, we are following the normal hearing processes and procedures in the Deschutes County Code, and I will provide sufficient opportunity for everyone to participate at the appropriate time. The application is being considered. The application is being considered through the quasi-judicial process, and I will consider only the factual evidence and any legal arguments that are in the record when we finally close the record. I will then apply those arguments and any facts that are in the record to and the relevant provisions of the county's comprehensive plan and land use regulations in making my decision. The standards and the applicable criteria relevant to this hearing were identified in the public notice announcing this hearing. They were also set forth in the staff report. The public notice and staff report are posted on the county website, and they are also directly available from staff today if requested. It is important that you direct all your testimony today to the standards and applicable criteria. If you believe a criterion or criteria does in fact apply or do apply that was not listed, then you may address the unlisted criterion or criteria. However, I urge you to also explain why that specific criterion or those criteria must apply, and to do so with specificity so that you allow both me and other participants in this hearing to address that issue, particularly in my opinion. The failure to raise an issue with enough detail to enable me or the other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed conditions of approval with enough detail to allow me to respond to the issue in my decision precludes an action for damages in circuit court. As just noted, I serve as a county hearings officer and have been appointed in this matter. In that role, it's my job to be a neutral decision maker. Thus, while I have a contract with the county to serve as a hearings officer, I'm obligated to remain impartial, and I do not represent the county's interests or the interests of any other participant in this case. To that end, I will state for the record that I do not have any relationship with the applicant. Don't know the applicant. Don't know any representatives of the applicant that I'm aware of, and I'm not aware of any connections that I may have to other participants in this proceeding that would prevent me from remaining impartial. I have, in fact, communicated with staff, but only to discuss logistical particulars of today's hearing and not the substance of the application. The exceptions to that would be that I have received a staff report directed to me by staff, and they've also directed me to the appropriate web link so that I can access the materials that came in on this case. I do not have any ex parte contacts to disclose. It is my obligation to preside over this hearing in an efficient manner. And at this point in time, I just, and this is more curiosity than anything else, Ms. House, how many does it look like we're going to have speaking today?
So it's just the applicant's team. There's no one attending remotely. And so it's just the applicant and their representatives.
Okay, and the reason I asked that, particularly directed this comment to the applicant and representatives, is that I kind of want to know whether or not I have to impose any time limits. And since we have a relatively few people that appear to be going to testify, I will not place any time limits at this point in time. Before we begin this hearing, I would ask anyone that is attending this hearing if they wish to challenge my ability to hear this matter or to challenge the county's jurisdiction in this matter. Ms. House, anybody responding to that?
No, there are no objections.
Okay, and the final thing I have to indicate is that in a hearing, when all the testimony has been completed and you've submitted whatever you want to staff, I would close the hearing later today, like after the last testimony. But anyone who wishes this hearing to continue to submit additional information into the record, in other words, additional time to respond to something that either applicant or Ms. House or someone else brings up. And in this particular case, just going to highlight to you, I may have a couple questions that staff has raised that I'd like clarification on. If you wish the record to remain open, anyone who is participating in the hearing may do so. And I'd ask that during your testimony, certainly from the applicant's perspective, before you complete your rebuttal, or Ms. House, before you complete your final comments, that I know whether or not we're going to have an open record period so we can talk about the logistics, the timing, and the how-to of that kind of thing. So with that, I'm going to turn it over to staff. But before actually I do that, and I think in this particular case, and in Ms. House, this is a bit unusual from a procedural perspective from my what I'm doing, but I think it's helpful having reviewed the staff report. In this particular case, since the record's not huge, I've reviewed the burden of proof, not all the attachments. I admit not all the attachments, but the burden of proof. I reviewed the incomplete letter And I've also reviewed a couple of cases that were cited by applicant in the quoted material in the staff report. So those things I've looked at. It doesn't mean I know them well. It doesn't mean I understand them perfectly and have not made a decision, but I want you to be aware that I've looked at those. So let me just sort of bring to your attention the things that when I'm listening today, that I'm kind of listening for. I've kind of broken it down into 3 or 4 particular items. The first one is a tract issue, a tract issue. And this is something that was raised by Central Oregon Land Watch in their response. And so when I look at Deschutes County Code 1804025C2, it talks about same lot or parcel for dwelling that we're talking about. I think replacement dwelling, but I'm open to be educated on that. And I don't see the word tract in that particular section, and I don't know how important that is. And so what I'd like to have is some additional assistance in understanding whether or not the word tract as raised by Central Oregon Land Watch is even relevant to this case. The second part that I'm more looking from the applicant's perspective is 1840-060. I think it's C, but I'm not sure. But it's the impact analysis, and the applicant cited Sisters Forest Planning Committee versus Deschutes County. I would like, before you come up, the applicant or applicant's representative, to make sure I have a citation to the case that you're looking at, because this case citation I saw in the staff report referenced a LUBA decision, which I read and didn't really relate at all to what applicant was raising. But there was also reference to court, which I'm assuming is the Court of Appeals case, which I believe the citation is 198 Oregon App 311. If that in fact is the case, then the applicant should be prepared to kind of help me out understanding where you got the sites and how I should be interpreting the language that you have with reference to that particular case, because it's brought up a couple different times. The last 2 things that I have relate to the bridge, which is 1840-080A. And I would just like to have some additional discussion on both staff's perspective and the applicant's perspective on that. And final thing that I have is reference to applicants raising the issue of a collateral attack. I've certainly reviewed the Ganson case just because I wanted to more than anything else, but it's certainly something that's come up in additional cases that I've heard in the city of Bend particularly. And I'm not sure how it applies here, but my understanding is it stands for the proposition that prior unappealed decisions are not subject to a current attack regarding validity. And that makes entirely good sense to me. What I don't have a good handle on is there a distinction between the revocation or invalidating of a current permit or approval. For example, in this case, invalidating the right to have the dwelling that's on the property at this point in time, and how that compares to a proceeding to determine whether or not the current residence was lawfully established. I don't know if there's a distinction there, but I'd like some help on that. So with that, I'm going to turn it over to staff. Ms. House, the floor is yours at the conclusion of your staff presentation. I may have some questions, but I've kind of already asked the questions before I even start. So hopefully you can help me out a little bit with that. After that, it'd be the applicant or applicant's representative's opportunity to speak. Ms. House?
So I have a pretty brief staff report today. The county is just, again, asking the hearings officer to focus on the issue areas identified in the staff report. But just the basics for this request, the subject property is located at 67705 Three Creeks Road in Sisters. This is just south of the city of Sisters urban growth boundary, and the property is approximately 10 acres in size. The applicant has requested land use approval for a replacement dwelling of a lawfully established dwelling in the forest use zone, and also has requested approval in the wildlife area combining zone, and has used a historical photo to demonstrate the dwelling will be sited within 300 feet of that road. As I previously mentioned, staff's asking the hearings officer to focus his review on the issues already identified in the staff report, but all materials related to the review are located on the website that is shown on your screen. That's really all I have, but I know you had some questions, and the main one I think that you were asking for staff's feedback on was related to the bridge requirements. And I believe, and just talking with my colleagues, that the issues raised related to the bridge are things that could be addressed by supplementing the record with additional materials. And that's, I think, an approvable standard with just more information. I don't know if it would be appropriate to condition those requirements to a later date because of the bridge being located on the Deschutes National Forest lands and also being over White's Creek, impacting potential irrigation facilities, et cetera. It seems like there may be additional permitting requirements that I don't know if would be feasible to be obtained. So it seems reasonable for the applicant to demonstrate compliance with those standards at this point or as part of an open record period submission. And that's all I have, unless you have more questions for me.
Any comments on the collateral attack argument that you raised and asked me to decide whether or not there's going to be a modification or something else?
Nothing to add except for what's in the staff report. Again, I think the county's position is that the FMP Forest Management Plan dwelling is not invalidated. That's not the county's position, that other dwelling on the adjacent parcel has to be removed. There's just a question by the county of what impact does the development that was shown at the time of that application or lack of development have on the subject application? And I think that's something that we're asking for the hearings officer's interpretation on.
Thank you. And nothing on the tract issue as far as Central Oregon Land Watch's argument that there's already a residence on the tract if you include the 50 acres, which would make 2 residences on a tract, if I read it correctly.
During my staff review of my staff report, I didn't think there was a nexus to that argument, so I didn't put anything in the staff report. So I'm not aware of a standard that would apply that would limit it based on it being a tract and there being a dwelling or property.
I appreciate that. All right, this is time and place for the applicant or applicant's representative. When you come up, if you give me your first and last name, spell your last name, because actually, if you think I can misspell your first name, spell it as well. And then if you could give a mailing address so that decisions can be mailed.
Hi, Hearings Officer Frank. My name's Rand Campbell. My firm is Rand Campbell Law, LLC. My address is 20350 Tumalo Road in Bend. The zip code's 97703. I'm one of the attorneys for the applicant. Adam Smith here is also joining me. Adam's with Schwabe, Williamson, and Wyatt. Their address is 360 Southwest Bond Street, number 500 in Bend, zip code 97702. I'll begin our presentation by discussing some of the background of the application. And Adam will follow up discussing some of the procedural issues, and we'll be going back and forth, kind of dividing the topics throughout our presentation. I was, as an initial matter, going to ask that we have more than a half an hour of time, but I think you've clearly addressed that we'll probably have plenty of time, given that there aren't a lot of people in attendance today. And then one thing I wanted to clarify, when your citation about the tract issue, I think you said 1804025 C2. But I think what you meant is 1840060 C2. Is that correct? It's
Could be,
the impact analysis and
could
the
be.
track in there.
It's the one that roughly parallels 215, 291. Yeah.
Yeah, I think that's it. It's ensure that adverse impacts on forest operations and accepted farming practices on the track will be minimized. Is that?
It says same lot or parcel. Let me pull it up quick. No, I was citing the one I wanted to.
Okay.
What was that site again? I just didn't catch it. And I apologize. I'm hard of hearing and big room, not great speakers.
Ms. Smith, that's why I have my ear pods in instead of my
I
hearing
understand.
aids in, because I can really hear you clearly. So fully appreciate that. No, I'm looking at 1804025 C2A. And the reason that I brought that up is I was searching for in the staff report in the bold print, which has the relevant approval criteria. I was searching for the word track. Each and every one that I was reviewing, I didn't find it, but this one I did find, and it looked like lot and parcel are the phrases or terms that were used. I'm not indicating that I'm an expert on this. You're going to make me that, but that was the citation that I gave you, and it was the one that I was intending.
Okay. Thank you.
Do you, can we pull our slides up?
Mr. Smith, if you want to identify yourself before we get moving along.
Oh, of course. Sorry. Adam Smith, Robbie Williamson and Wyatt, 360 Southwest Bond Street, Suite 500, Bend, Oregon, 97702.
Go ahead, sir.
No, I should be okay. I could turn them up. And what were you saying that we were driving from here? Okay.
Where is it? Oh, it's up there. Okay. All right. I kind of thought I would be a little closer to the map for this presentation, but I'll do my best to point things out from afar. So the subject property where the dwelling to be replaced is located is 10 acres. It's this rectangle outlined in black. The other property to the south is a 40-acre property that's also owned by the applicant. This red line on the map is the access road, and we're going to talk about all of this in more detail. But the access road crosses Deschutes National Forest. That other road you can see on the far east side is Three Creeks Road. It's a pretty main paved road, and then this access road comes off and accesses the subject property. The subject property is in the F2 zone and wildlife overlay. And then next slide. So something we'll be kind of referring back to throughout this presentation is that the two properties are two separate units of land. They're two different lots of record. The lot of record status was established in file number 247-22-00002 lot of record. And these two properties are, as shown on these diagrams or maps, are the two different lots of record. Next one, I'll kind of give you some background on the history of these two lots of record, because there's the houses on them were originally approved a very long time ago, and the records are spotty. So I think that's led to a lot of confusion during this application. So on the 10-acre property that has been That lot of record was created as a remainder parcel in 1965. A lawfully established dwelling was first established on that property in 1970, and that first dwelling was a manufactured home, and then the existing manufactured home replaced that first manufactured home in 1979, and then the same manufactured home has been on that property in the same place since 1979. And then on the 40-acre property or unit of land, it was created by patent deed in 1909, and the description on the patent deed's the same quarter section as it is today. There was a lawfully established dwelling on this parcel in 1955, and that dwelling was a stick-built house. And that stick-built house was later replaced by the existing stick-built house on the 40-acre property. And that 1955 dwelling was removed from the property at the time the existing stick-built house on the 40-acre property was constructed. And the approval for that, the existing stick-built house on the 40-acre property doesn't talk about the removal of the old house, and I think a lot of confusion stems from that. But we have submitted assessor records with showing that the dwelling was there, and then there's a line crossed through it made by the assessor saying "gone." There's even pictures of that old dwelling. So then, Adam, if you could go to the next slide. So this is a map I prepared. I'm kind of a visual person, and I think it's helpful to see the two different properties and where the houses are located. As you can see here, the property to the south is the 40-acre parcel. That's where you can see the arrow there to where the existing stick-built house is. There was a previous stick-built house close to that house, and then on the subject property, the 10-acre unit of land in the north, there's an arrow there to where the manufactured home is currently located, and the previous manufactured home was in that same place. And then I'm gonna hand it off to Adam to talk about some of our procedural objections.
Real fast, actually, I think, well, I'll set the stage. We wanted to lead off with some procedural objections just because it's important to us to try and put some parameters around this application. We've been confused throughout these proceedings. Mr. Frank, from some of your questions, it sounds like you may be as well, and what's appropriately in front of you, what's not appropriately in front of you. And so we want to kind of set the stage there. I noted, and I'm going to make the same mistake. I'll do the same thing. But I noted even in Rand was talking about these things that we're interspersing parcel, lot. On our slides, we tried to refer to them as units of land. But this is relevant, Mr. Frank, to your question about the citation. And so I wanted to note that. So first, just real quick on terminology, at least when we're referring to property, these are these two units of land, the 10-acre and the subject 10-acre and then the adjacent 40-acre that seems to keep being dragged into these proceedings. Neither of those parcels, or excuse me, I just made the same mistake. Neither of those units of land are parcels or lots. Under state law, right, as we all know now, parcels are created by partition, lots are created by subdivision. These were neither. These are the creation of these units of land predated those definitions. And I think probably the most appropriate terminology would be a unit of land. That being said, I have no doubt that we will slip back into more informal terms throughout these proceedings, as has already occurred. I think that's notable because I think that's what is the root cause of a lot of the confusion in this case all along. The confusion in the law and even in Deschutes County Code, when we're talking about different units of land, doesn't stop with just a parcel, lot of record, tract, tax lot. All of these terms get thrown around and have been thrown around pretty interchangeably throughout the decades that Deschutes County's been handling land use. It's not, this case is a little bit interesting. I mean, I think Rand and I get calls every single day from somebody who claims, hey, I have 2 tax lots. Does that mean I can build homes on each? And we're like, no, tax lots have nothing to do, literally nothing to do with the legality of the unit of land. Tax lots are entirely created and utilized for the assessor's office. Yet we, even CDD's applications regularly refer to what is the tax lot we're talking about. And I'd say it's more often the case that, a section boundary splits a unit of land. And so a property owner has 2 tax lots and they think that means they have 2 separate units of land. This case is the exact opposite. This is 2 separate units of land. It's always been 2 separate units of land. It's been 2 separate units of land from the beginning of time, since well, maybe not the beginning of the time, but since these properties were patented and provided into private ownership from the federal government. The fact that there was a recent lot of record decision just a couple of years ago doesn't change that analysis. They didn't become separate units of land 2 years ago. They have always been separate units of land. Sure, they were combined, as Rand just noted, into a single tax lot by the assessor's office. And that probably led to some confusion on some of the applications that were submitted by our client, but they have never ever been 1 unit of land. So noting that, and I did want to speak to you to the specific language may be cited on any part of the same lot or parcel. Again, I mean, we have to be a little bit circumspect with how we interpret that, because these are neither the same lot or parcel, or excuse me, neither unit of land is a lot or parcel. But Deschutes County has approved replacement dwellings on unit of land forever. I mean, numerous cases were interpreting that lot or parcel language more generally than what state law defines. And notably, it doesn't say anything in there that you cannot cite a replacement dwelling on a tract if there is another dwelling on another separate unit of land. So hopping into our procedural objections, and we unfortunately are raising some of these things, I would say almost reluctantly. We have the utmost respect for staff. We work with staff on numerous applications day in and day out, but we are frustrated, to be honest, with how this application has been processed. I think there have been some questions that are pretty easy and should have been easy to address that, we keep pulling on threads that are going nowhere, and it's really casting a shadow on making this application much more complicated than it needs to be for a simple a simple replacement dwelling. So our first objection really stems from the incomplete letter. Both state statute and Deschutes County Code, which I've quoted on the screen, require that staff provide the applicant in writing exactly what information is missing. In this case, staff's January 17th incomplete letter raised only 4 issues that were all related to 1840-070. But then the staff report that we received just 7 days ago goes well beyond those 4 issues. So that's really put us on our heels and has put us in a disadvantage being prepared to even address all of those issues during today's hearing. But that's why we actually put together a presentation. Mr. Frank, I apologize that this is a very wordy presentation. I like to put pictures on screens and not words, but in this case, we really had no choice. We really needed to cite some statutes, cite some law, put some arguments out there for you. I'll do my best to not read the slides for you, of course, and I've highlighted what I think are the key issues here. But again, we apologize for the wordy slides. So how does staff's, the incomplete letter, the fact that the incomplete letter and the staff report don't really line up, how is that, what's the relevance of that? How are we harmed? How have our clients' fundamental rights been harmed? Well, if you look at the staff recommendation at the end of the staff report, they're directly noting and recommending that our client's application be denied because they state that the applicant, they're recommending that the application be denied unless and until the applicant submits additional information addressing the issue areas identified in the staff report. Well, that is a fundamental due process issue. It doesn't say unless the applicant addresses the issues that were raised in the incomplete letter. It says unless the issues that were raised in the staff report. So that means in the same moment, in the same instance that county staff raise new issues in the staff report, they're then recommending denial because we haven't addressed those issues. As we all know, due process requires notice and an opportunity to be heard. I mean, how were we provided notice of these additional issues? How do we have an opportunity to be heard on these issues prior to staff making the recommendation to deny the application? And that shouldn't be taken lightly. I mean, staff very, very, very rarely recommends denial of an application. It puts a pretty big shadow over the entire proceedings. And in this case, to cast a shadow recommending denial over on these entire proceedings on issues that we never had an opportunity to address prior to the staff report being issued, we think is a due process issue and a clear procedural error. So we're trying to be self-interested and moving forward. As I said, we have the utmost respect for staff. We're not raising procedural objections for the sake of raising procedural objections and to preserve our rights for LUBA appeals. No, we're just trying to move this forward in a fair and equitable way. And so for each of the procedural objections we're raising, we're providing a proposed resolution. And in this particular case, we think the clearest answer is that staff should be limited to raising only the issues that were addressed in the incomplete letter. Now, I know that seems like it's a pretty draconian remedy, but let's be perfectly clear. I mean, it doesn't really fix anything from our perspective. Any other party, and it is notable that nobody else is here, but any other party theoretically can just copy and paste staff report and say, we now are raising all these issues. So just saying that staff can't raise issues unless they were raised initially in the incomplete letter, unfortunately, doesn't really cure things for us. And if any other party raises those other kind of issues, then that leads us naturally to our second procedural objection. So our second procedural objection, focusing directly on state statutes, ORS 215-4279, and this is the shot clock, the 150-day clock statute, the last subsection. A county may not compel an applicant to waive the 150-day deadline as a condition for taking any action on an application for a permit. Well, staff raising new issues in the staff report functionally forces us to either ask for a continuance or to ask for the record to be left open so we have an opportunity to respond. I mean, certainly the 7 day, I mean, I have no doubt that staff spent more than 7 days preparing the staff report and we were given very little time to respond. And so that puts us in a position where it compels us to ask for an open record period that we think is procedurally inappropriate, and it functionally is compelling us to toll the clock. Again, we have a proposed remedy. Our recommendation is that the hearing officer on Mr. Frank, your own authority, grant a 14-14-7 open record period following the hearing. And we know this is, we're recommending that you grant the open record period. We're not asking for an open record period at this time. We're instead recommending that you grant that open record period to address the procedural issue that has been caused by staff. And so therefore, since we're not requesting it, you're granting it unilaterally, it should not toll the 150-day clock. So why an extended open record period? Really, if you look at it, staff had 30 days to issue the incomplete letter. The same day they issued the incomplete letter, we were notified that this matter was being sent to a hearing. So that meant staff had another 34 days to prepare for the hearing, and we were only provided 7 days to respond to these issues. I want to be surprised if staff defends, hey, a lot of these issues were raised in the initial application. As I'm sure you know, Mr. Frank, this is a redo of a previous application that was submitted. But from our perspective, we successfully addressed all of those additional issues, and we presumed as much when we got a very innocuous staff report, or excuse me, a very innocuous incomplete letter. I will note we were suspicious when staff told us that they were sending this matter to a hearing. We were suspicious that, there was maybe more to staff's objections because the pretty simple issues laid out in the incomplete letter didn't necessarily line up to going to a hearing. And so we repeatedly reached out to staff and asked to meet, to ask to understand what's the reasoning for going to a hearing. We requested meetings, and staff unfortunately never responded, never agreed to meet. We didn't sit down. We didn't unpack any of these issues until we got the incomplete, or excuse me, the staff report. So why toll the clock at all? Why is it important for us to, one, have an extended open record period? Oh, I guess to go back, we're asking for an extended open record period because staff had plenty of time. We're not asking for 30 days. We're asking for just 14 days to respond in the initial open record period. We're pretty confident we can do so in that 14 days. And more than 7 is just because staff certainly had plenty of time to prepare for this hearing, and we're unfortunately been put on our heels. So why not toll the clock? Well, quite simply, our client is eager to get this simple replacement dwelling approved. And the applicant shouldn't be penalized. I mean, if we have to consent to an open record period so we have the chance to respond, we'll talk it over. But certainly our client shouldn't be penalized for tolling the clock, extending this matter longer to correct staff's own errors. Right, time is money. Delays in applications cost more time, and they cost, therefore, our clients more money. And so our interest is in expediting this. And since staff, didn't show their cards at the outset, then they should have to deal with the consequences of a shortened clock, not our client. All right, so forgive me, this may get a little dense, but I think kind of these next 2 procedural objections, Mr. Frank, get right at the heart of some of the issues that you were asking about in terms of collateral attack, code enforcement, revocation. We're going to walk through all of these things. And yeah, I know we haven't necessarily, well, I think enough on you read the staff report, you're familiar with the application. I know we're mostly talking about these procedural objections, but I do think at least in one area, we need to kind of dig into at least the 1983 Forest Management Plan as part of explaining our objection. So bear with me, please don't hesitate to interrupt, to ask clarifying questions. I know this is a bit layered, and we'll try and walk through it for the benefit of you and staff to the best of our ability. So, the staff report on page 26 raises some of these procedural questions and suggests that the subject application either requires modification of approval, or if this procedural question should be handled through the county's code enforcement process. So staff presented to you that this is an either-or scenario. We either have to modify the application, or if we don't have to modify the application, they're saying, well, this raises code enforcement matters. And I think they're frankly dangling some of these code enforcement issues in front of you. We think that's both procedurally wrong and functionally entirely incorrect. It's not an either or. It's not a modification or a code enforcement question. It's a collateral attack, but we'll get to that later. So really, why is this not a code enforcement hearing? Why should the hearing officer not get sucked into some of these code enforcement questions that are being put out there by staff? Well, quite frankly, the county hasn't followed the requisite process to do so. Admittedly, there is a county code provision, 2220-015A, whereby if there are any violations on a property, the county is not supposed to issue new land use permits. And the county in that section defines violation to mean something that's been prior adjudicated or adjudicated through the review process of the current application. As I'm sure, I know that hearing Officer Frank, you've dealt with this provision before. As I'm sure you know, the county commissioners have interpreted specifically that provision and noted that adjudicating a suspected violation in the application as part of the proceedings, as part of the quasi-judicial land use application, should be done very sparingly, specifically because of all these procedural issues that I put on the screen. The county's required to the county's required to submit a notice of violation to the property owner. It has to be served. Prior to a code enforcement hearing, there's discovery that has to be provided to the applicant. And then very importantly, I think in this particular case, the outcome of a code enforcement hearing is not appealable to the county commissioners. It's of course appealable to LUBA, but that's a fundamental difference between a quasi-judicial land use proceeding and the county's process for adjudicating these code enforcement hearings, is that one, you have the right to appeal to the county commissioners, and the other you do not. Probably the most important issues from our perspective is that the staff seems to be doing a burden shift, that they're putting on us the obligation to prove that through these land use proceedings that, there is not a code enforcement issue. Well, that is fundamentally flawed. In a code enforcement situation, the county has the burden of establishing the violations. So unfortunately, as we kind of get into this, we're kind of having to get sucked in and demonstrate why there are no violations, but we should have never been put in that position in the first place. So hearing officer Frank, you also asked about a revocation hearing, and I'm glad you did. The staff report only mentioned code enforcement proceedings. I think that's probably a matter of semantics, but as a revocation, a code enforcement proceeding, I mean, I would offer that code enforcement is asking if a property owner is complying with an issued land use permit, and revocation instead is asking if that land use permit was issued appropriately in the first place. So I think there's a clear distinction, but I think county staff is more asking that revocation question here as opposed to the code enforcement question. And so we're addressing it along with the same procedural objection. And that's because it's the same issue. In the same way that there are unique and different procedures that have to be filed for a code enforcement case, it's the same thing for a revocation hearing. Deschutes County Code requires that revocation hearings are processes of declaratory ruling. Declaratory rulings can be initiated by a planning director or a property owner, presumably, of course. In the case of a revocation, it's going to be initiated by the planning director. But the planning director, when so doing, must state the precise question on which a ruling is sought. And again, there's a burden shifting that's occurring here. I mean, when the planning division does try and revoke a permit, which is very rare, I've never heard of it actually occurring, at least not in Deschutes County, then the planning division shall bear the burden. And again, the way these issues have been raised, which I think is being raised in this way to try and avoid the clear collateral attack doctrine, it's really putting us in a position where we're having to defend that the 1983 FMP was appropriately issued, and we're having to defend that the 1983 or our client's use of the property is not inconsistent with that 1983 FMP. Those are clear procedural issues. The county has not followed the requisite process, frankly, to be raising any of those issues.
Smith, I've held off making comments, but this one I will forget. And I used to have a saying with other hearings officers when they came to me for advice: is never leave the hearing room with something unsaid that's going to come back to haunt you when you're writing the decision. You probably felt that way as county counsel. But this one, I apologize for having to interrupt. The way I phrased the collateral attack question in my mind, not because I had made up my mind, I asked the question sincerely and legitimately, was based on whether or not the county's argument is actually and can legally and lawfully be addressed under 1840 020 or 020, which says that says alteration, restoration, or replacement of a lawfully established dwelling. And I'm only bringing that up as an argument, not as a decision. I'd like to be able to respond to that and say, okay, and I think I can say with no hesitation that the earlier approvals of the replacement dwelling on the subject property is a unappealed prior decision that attacking it in the concept of it's no longer valid is improper. What I'm asking you about is whether or not, in the context of a current relevant approval criteria, which says there must have been a lawful residence located in order to have a replacement dwelling replace that residence, does that allow for a reconsideration at this point in time in this decision only? It's not revoking, it's not invalidating, it's simply saying this current proceeding does not meet relevant approval criteria because it was not lawfully established. So, and I'm going around circles now. I apologize for that. So I'm just going to turn it back to you. But it's important that you understand where I'm coming from. Is I think there is a relevant approval criteria. I think there is a hook that consideration of whether or not there were problems with approving the earlier residence can be considered at this point in time, but I'm open to your comments totally.
Yeah. So, we'll get to, like I said, we're unfortunately being sucked into defending the issuance of the 1983 F&P. So we'll get to that in a minute, but let me address your more philosophical question from the outset. I would proffer that a lawfully issued land use permit must be presumed to be establishing a lawfully established dwelling until and unless a local government goes through the proceedings to revoke that permit. I don't think the language in M or in state law invites a violation of the collateral attack doctrine. I mean, I think that that language comes into play when somebody is seeking a permit for a dwelling and there is no permit history. Say that somebody built or placed a manufactured home on a property after the county started regulating the placement of manufactured homes, and they never got any land use permit at all. But, staff noted in their staff report that, our client who owned the property when the 1983 F&P was issued had the obligation to be accurate, correct, factual, and all of those in the application materials. And we'll address that a little bit later on. And that's absolutely true. But the moment in time to call out, hey, you submitted inaccurate application materials, I'm not saying that's what occurred here, but taking county staff's argument at face value, if you accept that there was inaccurate information in the 1983 F&P, the moment in time for the county to object to that, the opportunity that the county has to deny that 1983 F&P because of inaccurate information is before the application is permitted. Once the land use permit is issued and it's not appealed, it becomes a final land use decision. And recent case law, the Johnson matter, and even the case I have on the screen right now in Deschutes County, I think the very strong, clear policy guidance is that land use decisions, we're not supposed to open the book and go backwards in time when it comes to land use decisions. And I certainly don't read anything in 1840-020M that suggests just because it says a lawfully established dwelling, that means we're going back in time and reconsidering whether or not a past permit was appropriately issued. No, the answer is it was lawfully established because it's pursuant to a final land use decision and nobody appealed it, period. It should be just that simple. In this case, I don't think the 1983 F&P was inappropriately issued, and we'll talk about that in a minute. But I think it's pretty clear it's still a collateral attack, and I don't think anything in the replacement dwelling statute or how Deschutes County has codified that changes that outcome. So
Thank you.
I think this is a perfect time to talk about the collateral attack doctrine. I mean, we briefed it at length in the application materials. Mr. Frank, you noted your familiarity with the Johnson matter out of Lane County. I just wanted to just put a quote from a very recent LUBA decision coming right out of Deschutes County. I mean, this matter was, yeah, thank you. This matter was remanded by LUBA because a different hearing officer, not yourself, didn't fully address, didn't adopt findings addressing a party's collateral attack. And in footnote 2, they were explaining the collateral attack doctrine, and LUBA explained, I'm just going to read it. Forgive me, but I think it's helpful. Luba explained that in challenging a development approval that depends upon a prior unappealed land use decision, Luba will not review arguments that the prior unappealed decision was procedurally flawed or substantively incorrect, because such a challenge would constitute an impermissible collateral attack on a decision not before Luba. It's the same analysis here. I don't think that 1840-020 challenge or changes that. We're starting to slip into what's a jurisdictional and due process and fundamental fairness argument. None of us that's in this room today were around and dealing with the 1983 FMP. And so to go back in time and to try and judge who submitted what, who said what conversations happened at the counter, any of those kinds of things is well, frankly, it's just the antithesis of planning. Planning is looking to the future and planning for our community, not lamenting past decisions. And I think the case law is very clear that we don't collaterally attack land use decisions. I brought the collateral attack doctrine up at this point because I think, frankly, it kind of casts a shadow over the county's revocation proceedings as a whole. Again, I'm not aware of the county actually using those revocation proceedings, and they certainly have not provided or followed the process to do so in this case. But I got to tell you, if the county did, I think we would pretty quickly push back and say, hey, that's not, the county's revocation proceedings are inconsistent with the collateral attack doctrine. So our last procedural objection, and admittedly, this is a pretty substantial overlap with the one before. Going back to the staff report, staff really presented it as an either or option, that we either needed to modify the approval or asked you if this was a code enforcement issue. And again, it's not an either or, it's not flip sides of the coin, it's neither. And when it comes to the modification of approval, the county code's clear. An applicant may apply, not county. County can't force us to modify an approval. We don't think anything needs to be modified. But you certainly can't as through these proceedings. So, oh, we're going to interpret your application as really a modification and make you submit additional information addressing these criteria, pay an additional application fee. Oh, and if you don't do so, we're going to call it a code enforcement action. I mean, none of that is supported in the code. Substantively, when you get into it, a modification approval requires a change in circumstances, and the modification itself needs to be directed at one or more, sorry for the typo, one or more discrete aspects of approval. And so I think now it's an appropriate time to kind of linger and to talk about that 1983 FMP a little bit, because I think that really helps exemplify that there is no change in circumstances that would justify a modification in the first place. And I am at an utter loss at what the discrete aspects of the approval that we would be even trying to change in the first place. So, two key points. Well, actually, I'm going to give a little bit more background on my understanding of these forest management plans, because they're certainly not a feature in Oregon land use law today. This is not a mechanism necessarily for somebody to go and get a dwelling approved on any forest zone. But going back and looking at PL 15 and the amendments to PL 15 to try and understand how these forest management plans worked in 1983, you know, dwellings were a use allowed outright so long as pursuant to an approved forest management plan. So the application gets a little bit squirrely, because you're submitting an application to the planning director for a forest management plan, and ergo, once that's approved, that provides you that then allows you to build a dwelling as a use allowed outright. The use of the dwelling is not a conditional use permit. It's not a CUP. It's not. You don't go through conditional use criteria. It's the administrative, in this case, it was an administrative approval of an FMP, which then entitled somebody to put a dwelling on the property. I think that's an important distinction, because, you know, it proposes a couple of hypotheticals that I think are helpful in understanding. I mean, presumably a property owner, and this is just a hypothetical, not at all what occurred here, but presumably a property owner can own, you know, 5 20-acre lots. And I'm saying 20-acre lots because that was the minimum lot size in this zone back in 83. So if a property owner owned 5 20-acre lots and prepared an FMP for the tract, the entire 100-acre tract, and each one of those, and the FMP, presumed that a dwelling would be on each one of those 5 lots, then yeah, I think presumably the approval of that forest management plan would then entitle the property owner to put a dwelling on each one of the 5 lots, each one of what is addressed in the FMP. Stated otherwise, there's nothing that I found in PL 15 that requires a forest management plan for a unit of land, lot, or parcel, whatever term we want to use, and precludes an applicant from submitting an FMP for a tract. If, let's say, same example, you have the 100-acre tract comprised of 5 20-acre units of land, and the forest management plan presumed a dwelling on only one of the lots. Well, I think that would be perfectly fine too. It's the forest management plan is, draft. I mean, if the property owner wanted a forest management plan for the entire tract because they were presuming to manage that forest, those forest resources collectively, again, I don't see why that matters, that the forest management plan is for the tract as a whole. And if the forest management plan contemplated a dwelling on one of those properties, I think that would be perfectly appropriate. In this particular case, that second example is closer to what occurred. The only difference is that both the 10-acre parcel and the 40-acre parcel had dwellings on it at the time. And the dwelling on the 10-acre parcel, as Rand walked through at the beginning, predated the FMP by a number of years. There had been a dwelling on both parcels for years prior to the FMP. And when our client came in and asked, hey, I want to replace the dwelling on the 40-acre parcel, he was told to submit a forest management plan. And probably it was the easiest and most direct way to replace the dwelling at the time. Again, we don't know, like none of us were involved in those proceedings. And that's exactly why the law disfavors collateral attacks. But, it's not unheard of. And I don't see anything in PL 15 that precluded the applicant from then preparing a forest management plan for the entire 50-acre tract. And more likely, the applicant's consultants didn't understand that they were preparing a forest management plan for 2 separate units of land. They probably just looked at the tax lot. The county's applications at the time were asking for tax law references, and they didn't understand what people today, Deschutes County citizens, attorneys don't even understand today, that the tax lot is not necessarily consistent with the different units of land. And so they prepared a forest management plan for that entire tax lot, and then pursuant to that tax lot, that allowed a dwelling to be built as of right on the 40-acre parcel. And it had no impact on the 10-acre parcel because there was already a dwelling that was approved. Oh, I forgot to mention so this timbered acres, that's I just copied and pasted an image from the FMP, which is in the record, and you can find that yourself. The timbered acres and the FMP was listed as 44 acres. And as we know, the tract together, 10 and 40 makes 50. So we're missing 6 acres. I mean, the FMP acknowledged that there were only 44 timbered acres on the property. So I'm digging into the FMP for the clear, my clear intent here is to demonstrate that nothing that has occurred on the 10-acre parcel since the approval of the FMP is inconsistent with the FMP. So bear with me as I walk through this a little bit. So the FMP, as I just noted, states it's 44 timbered acres, and then it breaks out area 1, area 2, area 3, area 4, and it sets forth the different management plans, the different goals for managing the forest resources in those different areas. And if you add up the areas, they equal 50 acres. So that means within these areas, within area 1, area 2, area 3, or area 4, are those 6 missing acres. These areas, which set forth the goals, the objectives for managing the forest resource, include 6 acres that the FMP acknowledged were not forested. I think it's high probability that those 6 acres correspond to the dwelling sites on the 2 different parcels. I mean, it certainly is a rational explanation. And again, if this was a revocation or a code enforcement proceeding, it would be the county staff's burden to prove otherwise, not ours. I think it's a pretty logical inference that those missing 6 acres had everything to do with those 2 dwellings on the property, and that those 6 acres were then incorporated into these descriptions. Stated otherwise, I don't think if you make that connection that those 6 acres likely correspond to the 2 dwellings, one on each property, then the FMP is suggesting that those 2 dwellings are not inconsistent with managing the forest resources in each of these 2 areas. Again, second issue, the schedule of operations, which really laid out what was more specific activity. I mean, the previous areas kind of set forth objectives. This says also just copied and pasted from the FMP what's supposed to occur. You know, from 1982 to 2003, and I'll just read it, there will be little, I need to zoom in, forgive me. 1982 to 2003, there will be little forestry work to do in this period except to replant areas where reproduction has failed and continue to salvage disease or damaged trees as they develop. So if you're digging in, so right, you've got areas 2 in 1983 cleared, 1984 to 87, areas 1, 3, and 4 will be treated as proposed. 88 to 2003, we're just letting the trees grow. And again, let's not forget that there are missing 6 acres that almost certainly corresponds to those single family residents on each of the 2 properties. And the intention was within those areas from 1988 to 2003 to let them grow. I don't think this suggests, there's nothing in the FMP that comes anywhere close to suggesting that the pre-existing residence on the 10-acre parcel was inconsistent with these schedule of operations that set forward up until 2003. And that really begs the question, what was supposed to occur? What's the schedule of operations since 2003 for the last 23 years? There's absolutely nothing. The FMP doesn't govern the management of the forest resources at all for the last 23 years. So how in the world can we be suggesting that the manufactured home on the 10-acre parcel is somehow inconsistent with these objectives, or excuse me, these operations that have been set forward at least for the last 23 years? Tracing this back to the modification, which is what kind of started this down on this dialogue, what exactly are the discrete aspects of the or what are the discrete aspects of this 1983 FMP that staff thinks that we need to change? What are the change in circumstances? There have been no change in circumstance. There is nothing that we would go back and change. What do we change that, you know, from 2003 into perpetuity will continue to not be governed by the FMP at all? I mean, that's what it already says. There's no discrete aspect of this permit that we would need to modify at all. Stated otherwise, nothing that I find in the 83 FMP is inconsistent with the manufactured home on the 10-acre parcel. Nothing that I find in there is inconsistent with how our client has used that property. Nothing is inconsistent with how our client may use that property into the future. But what if we're wrong? Like, what if this is just our position? This is the applicant's, you know, this is our point of view. And of course, we're self-interested in this point of view. What if we're completely wrong? And yeah, there's some inconsistencies in that FMP. You know, it says vacant. I can't explain that. It also spells our client's name wrong. I can't explain that either. Right. So what if we're wrong? And yeah, the county succeeds and says, hey, these are material misrepresentations in this application from 1983. What if we're wrong and that the county's revocation proceedings, in fact, you know, are appropriate under, you know, are appropriate in light of the collateral attack doctrine. And the county goes forward and revokes that 1983 FMP. That has no impact on the dwelling on the 10-acre parcel. Revoking the 83 FMP would only have any impact on the dwelling that was then built on the 40-acre parcel. Again, nothing in the FMP governs any operations on either of the 2 parcels after 2003. So yeah, the county, sure, if we're wrong, the county revokes the 1983 FMP. Again, I think very skeptical that that would be approved or is likely to occur, but let's say it does. Then sure, yeah, then that house on the 40-acre parcel is not permitted. It would be a house on a property that has no land use permit. And yeah, maybe the county can then initiate a separate code enforcement action, try and get an injunction, try and get a court order, get it taken care of. I have no doubt that, we would argue vehemently collateral attack and estoppel arguments to the rest. But all of that would only have any impact on the 40-acre parcel. None of that has any impact on the 10-acre the 10-acre parcel and the dwelling on that 10-acre parcel that we are seeking to replace as part of these proceedings. Stated simply, the dwelling on the 10-acre parcel predated the 1983 F&P. It was not permitted by the 1983 F&P. The 1983 F&P has no legal effect today on the permit of that 10-acre, or on the permit for the manufactured home on that 10-acre parcel. Your findings don't change at all. It was lawfully established. It will still be lawfully established, and validating the 1983 F&P has nothing to do with it. It is just flat out a red herring argument. So to recap, and I thought a recap would be appropriate. I know I've talked for some time. I know there's a lot of things going on here. And I thank you for bearing with me. So objection number one, staff's incomplete letter is itself incomplete. Our proposed resolution is that county staff's participation should be limited to the 4 issues that were raised in the incomplete letter. We think that's the appropriate remedy for the procedural violation that clearly impacted our substantial rights, or client's substantial rights. Objection number two, raising issues anew in the staff report, in essence, directly compels us to toll the 150-day clock. To resolve that, we ask you, hearing officer Frank, to approve a 14-14-7 open record period on your own. And that open record period should not toll the clock. That for those 14 days, 7 days, the clock is ticking. We think that's an appropriate, or at least that's a sufficient resolution of the procedural issue in this case. Objection 3 and 4 overlap. We object that county staff is implicitly raising code enforcement and revocation proceedings and shifting the burden to us to prove otherwise as part of these proceedings, yet county staff did not follow the procedural formalities to do so. We object to that. And we also object that county staff cannot compel us to modify an approval, especially when there have been no change in circumstances and there is no discrete aspect that we would ever need to change in the first place, in lieu of then facing these code enforcement threats. We object to that as well. And the resolution, I think, is pretty clear, and I think it's consistent with the collateral attack doctrine. For these proceedings, we suggest that the hearing officer needs to presume that the 1983 FM was validly issued and that our client is in full compliance with the forest management plan. Until the county itself follows the procedures to suggest otherwise and then carries the burden to suggest otherwise, the only possible fair legal outcome is to presume that the 1983 FMP was appropriately issued and that our client is in complete compliance with that. And for all the reasons I just stated again, I don't think that's a hard inference to make. I don't think we're asking you to put blinders on to obvious flaws. I think the mistakes or inconsistencies are not material. I think they can all be explained by semantics. And I think if you really dig into that FMP, it contemplated that that there were 2 dwellings on these properties all along because they were there. That's what those 6 acres accounts for. And then again, there's nothing in the FMP that governs any of the forest operations on either of the properties after 2003. So we don't think that's a hard inference to make. We think it's the appropriate inference anyway, but we think it's also procedurally required in this case. And I'm happy to dig back into or to answer any questions or to address any lingering concerns from you, hearing officer Frank. And if not, then I'll turn it back to Rand to really start digging into the other issues that staff raised with this application.
Thank you, sir. I don't have any questions this time. You're going to have an opportunity for rebuttal, as you well know. And during that period of time, I'm going to raise issues both with staff and yourself. So let's proceed with the testimony.
Thanks.
All right. Yeah, so as Adam discussed, there were a bunch of procedural issues, but and I'm going to address the main issues, the lawful establishment of the dwelling and whatnot, and then there are these other evidentiary issues, a lot of them related to the access road, and I'm going to touch on those. But first off, I want to address a comment made by the transportation planner, and which notes that the intactness criteria of Deschutes County Code 1840 20M 1 through 4, that these criteria are met. So the transportation planner noted that the intactness criteria are met, but stated that it appears to staff that the use of the structure as an occupied primary dwelling has been abandoned. And I just want to highlight that there's no evidence in the record to imply that the dwelling has been abandoned. The staff report clearly says the dwelling meets the intactness criteria. And we're submitting a statement today from the applicant to this effect, confirming that the dwelling has not been abandoned and has been continuously used. We asked the hearings officer to make a finding that the dwelling has been continuously used and has not been abandoned. Then getting into some of these issues are really related to the building envelope, which is the proposed building site. If it's unclear, the building envelope is the dashed kind of rectangle, though on the western side there it's a curve because that side is set at 300 feet from the existing road that we could find maps for to show that it was there in before 1992. Because there's other roads that have, been in this same place for longer. But anyway, for the wildlife sighting criteria, then so this building envelope, it's about 3/4 of an acre. It's pretty small. That it has 100-foot setbacks on each side, and then is confined on the eastern portion of the property due to the wildlife overlay zone and that 300-foot distance from a public road. So I think the 3/4 of an acre building envelope is completely reasonable, as it's necessary to accommodate the future dwelling, any accessory structures, residential accessory structures, the road access and utilities. And the point of this building envelope was to try to have a reasonable area that provides some flexibility to site the dwelling. Things always come up when you go to build the building. Maybe you don't want to, just different factors of the topography or what have you. And so we just wanted to build in some flexibility, as the applicant doesn't have an exact dwelling that in mind, exact footprint. So we proposed this reasonable building envelope, and then discussed how it has the least impact on the surrounding forest lands. The staff suggesting that the setback from the east property line should be increased from 40 to 50 feet to eliminate development onto new areas not previously approved for residential development. Again, with the proposed building envelope was chosen because it's on the east edge of the property where the access road is already, where the access comes into the property and where the utility lines and the existing development already is, and it preserves the remainder of the property for forest use. But nonetheless, we're happy to consent to a smaller building envelope by moving that east setback to 50 feet, and agreeing with staff on that. So it's, that issue should be addressed. Then moving on to 1840-70 and the irrigation ditch being suitable for firefighting purposes. And the staff had asked us to verify. Well, I guess let me go back. The code language for this, Deschutes County Code provision requires that if there is a stream, lake, a pool, stream, or lake or a pond, then that's suitable for firefighting purposes, then you need to provide a road to that body of water. And we had provided pretty lengthy responses before, saying that the code language is talking about large bodies of water with, like significant volume of water. And this is a small irrigation ditch. Nonetheless, we talked to the fire district and they confirmed that this this irrigation ditch is not suitable for firefighting purposes. And that's the email right there from the fire district, and I'll submit the entire email, my email before that. I just didn't put it on the slide, but it and the previous slide had the pictures that I had sent the Jeff over at the Sisters Fire District.
Just to clarify, we did provide hard copies to Caroline, and we'll submit electronic copies by the end of the day as well.
Yeah, and that's kind of the same thing on a few of these emails. We'll submit better copies electronically. Okay, so next here, I just wanted to clarify this issue. It was brought up in the staff report. This picture that says irrigation ditch with the arrow, I had submitted that in response to the irrigation ditch issue. Basically I'd said, we don't think that you can pump out of this little ditch with the firefighting units, but if you think you can, there's already a road to the ditch, and that ditch and that road right there is then later in the staff report, this picture was brought up saying, oh, well, it looks like the road isn't gravel. And I just want to point out that picture is not the access road. I meant to be closer to this thing so I could point this out, but it's on the west side of that other picture. That's where this picture is taken. It's not the access road. That's the point. All right, moving on. So this is the access road here. Just wanted to show you that again so that it's clear. It comes off of paved road, and then this is a gravel road, and then it crosses White's Creek to the subject property. There's the two properties. And the road shown in red. And then you can go to the next slide. I also want to mention that before submitting the application, I tried to get to the bottom of all these issues and make sure, because I knew this road issue, it's always kind of hard to deal with the county, and I tried to confirm beforehand that 1840-80 could be addressed as a condition of approval, and I'll submit all these emails. But this is a copy of it, and the next couple slides are the same thing. But basically, I started by asking the transportation planner if that could be conditioned. He said, yeah, most likely, but you should check with the planner assigned to your applications. And then this was before I submitted the application. I then emailed Dan DeMarzo because I was dealing with him with the kind of talking about the pre-app. He said, yes, engineers, driveway access, engineers report, etc. to satisfy 1840 80 can be included as a condition of approval. Then later, after some further discussions, not about the conditioning this, but we got another email confirming that these could be conditioned. So that said, now we'll get into the issues raised in the staff report. So there's a issue with raise that the bridge isn't designed to support a 50,000-pound gross vehicle weight. This bridge was built in 1997, so I mean it's a fairly new bridge. That we submitted the actual bridge engineering plans, and this is the most relevant portion of those. This picture that's on the slide. Can you read that, Mr. Frank?
Kinda, yeah.
Okay, all right, good. So
Mr. Campbell, let me interrupt.
you know,
Mr.
this on
Campbell,
Forest Service land, so it had to get approved under Forest Service federal standards. You know, they don't use the same 50,000-pound gross vehicle weight, and they didn't in 1997. But this bridge is designed for a AASHTO H20-S16 loading with a maximum vehicle weight of 72,000 pounds. It's shown there. That's what the top figure is. That's like a semi truck with 72,000 pounds. Clearly the bridge will hold that weight. Then the bottom one, and then if you go to, so then the next little diagram thing below, that's for a cement truck. So the bridge is designed for the 72,000-pound vehicle, but it's also showing that a cement truck with with the axles close together, because that's going to have a different load in it will also support that at a 52,000-pound vehicle weight. And again, these are based on the AASHTO standards. And staff just had noted in the incomplete letter, or the staff report, that they couldn't find any information identifying GVW, which is gross vehicle weight, or similar language. I think loading total weight is similar language. We're going to submit today a new bridge inspection report that was just done, and the engineer also provided some guidance as far as that weight holding capacity. And all right, you can, okay, next slide here. You can see, so one issue was that the bridge wasn't designed for the 50,000-pound gross vehicle weight. We've shown through the bridge's design plans that it is. Then the other was that it was not maintained to support this weight. And there had been the applicant has gotten a number of bridge inspection reports over the years. But we got another one just like this week, and we'll submit it today. And in that, Mike, the engineer, included a piece, because that says the bridge was designed to AASHTO H20-S16 loading with a maximum vehicle weight of 72,000 pounds. And then the bridge inspection report says that the bridge is maintained to support this weight. And I mean, it's maintained to support the weight that the bridge was designed to support. That's addressed. Caroline, I'll just wait for a sec and then give you all these. I kind of thought Mr. Frank would be here and I'd hand them to him. And then there's so this road, the access road, the county code requires that there's 20 feet of horizontal clearance and 13.5 feet of vertical clearance along access roads in the forest zone. As I mentioned before, the access road crosses Forest Service land. The applicant and the previous owner of the property have had a Forest Service road use permit, and we've submitted a copy of that. And that permit provides a 20-foot wide right of way. And then staff questioned whether we could whether the Forest Service would basically give us approval to clear it to a 20-foot width to meet the county standards, and we went and got the Forest Service's approval. I'll note there's one narrow spot on the access road where there's 19 feet between these trees. That's what's shown on the picture. The left picture there, it might be a little hard to see, but there's other pictures in the burden of proof statement that show this, and I measured it with the measuring tape, and it's 19 feet. But anyway, the Forest Service said, we can remove any trees, any vegetation within the 20-foot right away. So that issue has been addressed. And then going here onto the turnaround, I don't think there's any major issues with this. Staff just wanted us to acknowledge that the turnaround would need to be verified by the fire district or an engineer, and the applicant is happy to agree to that condition. Just to clarify anything else about this turnaround, we really propose to meet this as a condition so that when the house is built and, obviously the roads are going to be improved and in driveways, extended and whatnot, and there'll be construction equipment there. That's the time to build a turnaround, and there's plenty of space here to have the turnaround and have it, suitable for emergency vehicles to get in and out of there. Adam, can you go to the next slide? And I just included this too. So this is a picture that I took last summer, and it's basically in the middle of the building envelope, looking south, and it's looking right at the turnaround area shown on red or highlighted in red on the site plan, and it's flat, and there's already roads right there. I mean, the fire truck could go in there and turn around today, but anyway, the applicant's happy to make a turnaround with 50-foot radius and have that verified by an engineer or the fire district. And so those are really all the evidentiary issues. We'll again submit the documentation I referenced showing that we satisfied all the issues raised. I was trying, if you have any questions, please let me know.
No, I appreciate your testimony. It appears that, at least for the most part, you responded to staff's evidentiary shortcoming concerns. So I'm not saying anything more than I think you did it. But
all right, thank you.
I'll take a look. Additional testimony on the applicant's part.
That's all we have for now. Of course, we'll provide any rebuttal that may be warranted at the end of the proceedings.
Yes, thank you. Staff, this is your opportunity. I'd like your first response to be to the timing request for the open record. I'm not concerned whether, I just asking for your comments regarding the 14-14-7 open record period in the context of not tolling the time clock.
I'll ask county counsel to come up and speak about the county's position on that. While she's coming up, though, I did want to clarify one thing, Greg, for you. I know this is not specific to your question, but for citing Deschutes County Code Section 1804025, that new section of code that was adopted or became effective, I should say, after this application was initiated. So it is not in the staff report for that reason. And the citations in the staff report go to the ORS because that was the provisions that were in effect at the time this application was initiated. And I'll turn it over to county counsel.
That's really helpful because I could have easily overlooked that. Thank you. Identify yourself for the record, please.
All right, Stephanie Marshall, Senior Assistant Legal Counsel for Deschutes County. Good afternoon, hearings officer. So there were just a few things that I was going to go through, but I think your first question really had to do with the open record period. And if I understand staff, I don't believe that we need additional time unless the applicant is to submit something, then of course, but we're not asking for additional time. And we certainly aren't asking the applicant to waive the time period or the clock at all. So just for clarification purpose.
With respect to that question, and it's either you or staff, I don't care who answers it. I've been doing this a long time, and every time I talk about open record period on my own, in other words, I initiate the conversation, say this is what I'm going to do. I would say frequently I get a response from staff saying, yeah, but we have the following deadline. You're putting us in a position that we can't get to council if in fact our commission, whatever. It looks to me like based on the template that I received for my opening comments, that it says today 2/27 is day 37 on the 150-day clock. I'm not expecting Miss Marshall you to know that because you weren't the one that sent me that. But somebody needs to. I just don't want to stick my foot into a timing issue because I don't care whether or not the whose motion or request it is, and I don't care whether or not that it's told or not. I just need to know what I'm creating for the county in order to get a decision in a timely manner.
Understood. Yeah.
So I can at least respond to that. So I don't think there would be sufficient time for the county to have a second hearing proceeding in front of the Board of County Commissioners with that requested deadline and given your lead time to get the decision out. So I do not think that would leave sufficient times for the Board of County Commissioners to hold a second hearing on the matter. To answer your question, I think that's what you were asking.
It is. So, and now I'm going to do something that's putting you in an unfair position. How many days? Normally, and I'm using your template that you gave me with the dates. Normally, it'd be 777. I'm presuming or assuming, with all that means, that the 777 isn't creating a time crunch for an appeal hearing.
I'm just doing the math real quickly. So day 37 plus 21 plus I think 3 weeks generally for your decision. The notice for the first board evidentiary hearing, their process, everything. I still don't think without the applicant pulling the clock. And again, I'm not trying to compel them. I'm answering your question. I don't know if there would be sufficient time for a second hearing. Generally, applicants, when they want an extension of the clock, they request it and they agree to tolling this. So this is, in my experience, at least, I've never had an applicant make this kind of request before. So this is a matter of first impression. I don't really know.
No,
How to respond to it.
I appreciate your answer. And without putting you under further pressure, I'm not going to ask you for how many days we're short to adequately allow for an appeal hearing. So if you had that date or had that number of days, that would be helpful. But it's if, for example, if we're off by 7, if we're off by 14 days, that would be helpful. I know I'm putting you on the spot.
So again, if we do a 777, which would be, I think, the minimum standard we have to do if there is an open record period. Here, I'll just get a calculator up and we can do the math real quick. If we do today's day 37 plus 21 on the clock for an open record period, then your decision, I think you contractually have 21 more days to write the decision.
Technically.
And my computer's being slow here, so if you bear with me. So 37 plus 21 plus 21. So then there's a 12-day appeal period that follows so with a 777 plus your 3-week contractual decision timing. Then there's a 12-day appeal period following that. That puts us at day 91. We would have to schedule the hearing based on the board's schedule. That notice has to be sent out a minimum of 10 days. I would assume, I'll just go with the minimum here, 10 days. Then the board has to hold the hearing. There could be additional open record times. They have to have time for deliberations, review of the decision, and either the applicant, if they are the prevailing party, has to write the decision, or staff has to have time to write the decision. That's just not enough time, in my opinion, at least, to get through the process. And I can't answer your question on how to reduce that, but maybe those types of calculations, you can come up with some other schedule that you think will ensure there's time.
Okay, thank you. Mr. Smith, before we go to Mr. Smith on the timing issue, anything else that staff wishes to raise at this point in time in your comments?
Sure. Again, Stephanie Marshall. I can briefly touch on some of the procedural objections that Mr. Smith was making during his presentation. I think that some of the first two at least kind of tie into this clock issue, this clock question. I do also want to, the first one had to do with the incomplete letter, and perhaps an implied argument that somehow removes or waives certain provisions, certain applicable criteria. And there's no support for that argument in statute. If you look straight at ORS 215-427, sub 2 addresses an incomplete letter, which is focused on missing information. And then when you go to sub 3, it talks about approval or denial shall be based upon the standards and criteria applicable when the application was first submitted. So there's no change in the applicable criteria. There's no waiver by staff. It's an information gathering exercise that's statutorily allowed. Very often these incomplete letters are, helpful to the applicants. They provide some additional information and a pathway towards getting to a yes. I think that first argument there's no support for that in the law. And then the second argument, trying to see, the staff report. There's no allegation, no proof that the process provided with the 7-day advance submittal of the staff report prior to the hearing. That's consistent with applicable law. And the new no due process argument, it's up to the hearings officer to decide, but, we've now been here almost 2 hours. And so there was quite a bit of preparation. There was time for all of that preparation to make those arguments. Again, the staff report was issued in a timely manner, and nobody has said otherwise. I think just one more that I'll touch on. This is not a revocation proceeding, and hearings officer, I think you were on the right track when you asked some questions regarding that. The applicant has the burden of proving that it's a lawfully established dwelling. Revocation, and this, we're shifting the burden of proof and all of that, it doesn't take us away from what the applicant has to establish in order to get a land use approval. So I just wanted to touch upon that as well. And Caroline, if you had anything that you wanted to add on the last objection with respect to the template and the calculation of the acreage and all of that, I'll turn it back to you.
The only clarification I'll have, at least my reading of the original forest management plan, if you look at the acreages, they actually total of the 4 areas. There's 44 acres within the 4 areas that are identified as forest use, and the 6 acres that the applicant referenced in their oral testimony is clearly identified as the proposed building site as part of that forest management dwelling. It's identified as, I don't have it pulled up, but I think it's either area 3 or 2 if you look at the forest management plan. So you'll be able to find that pretty easily, I believe.
Ms. House, Mr. Smith referenced the 1983 application and the forest management plan as being directed towards the dwelling on the 40-acre parcel. Did I misunderstand that? And if I did, I need that clarified.
I agree with the applicant, and Mr. Smith's testimony specific to, I was not here in 1983. I was not born, in fact. Don't know.
I
But
was, sorry.
exactly, that was, the whole full history. But what I can say is when I look at the plan, the legal description for the forest management plan is for 50 acres. It describes the subject property, which is 10 acres, and the property to the south as part of the legal description for the forest management dwelling.
And I
So
don't dispute that. I think I agree with that. What I'm looking at is the 1983 approval. That was for which parcel? Which unit of land in the language of the applicant?
I would have to go back and look at the original application, but I think at that time, and this is one of the issues the applicant identifies, is that it was one tax lot. So there's not a clear, other than the legal description in the forest management plan, my recollection at least, and if the applicant would probably want to support, respond to this in their submittal if there is an open record period, is that the legal description of the forest management plan is the subject property for that approval. It's not limited to the 40 acres to the south.
Okay, and I'm not disagreeing with that. Okay, I'm totally agreeing with that. In fact, let me just ask the applicant that, and I'm going to shift the burden over to the applicant, unless you have anything further.
I do not
Okay.
either. Thank you very much.
Yes, thank you both. Mr. Smith, either I misunderstood your testimony or misinterpreted it, one of the two. But as I said, my advice to hearings officers who I train is never walk out of this room without having enough information that theoretically you could write a decision. And right now I'm confused and don't know exactly what the answer to my question is. You made constant reference to the dwelling on the 40-acre parcel, and also in the context of the FMP. Flesh that out for me, so if you would please.
Yeah, absolutely. So the dwelling that we are seeking to replace on the 10-acre parcel predated the FMP. The manufactured home was placed prior to the FMP. That manufactured home is still there today. The 1983 FMP did not affect or change or have anything to do with the legality of the manufactured home on the 10-acre parcel. There was a stick-built dwelling on the 40-acre parcel prior to the 1983 FMP. And after the 1983 FMP, the applicant applied for building permits to replace that stick-built dwelling on the 40-acre parcel. There's no doubt. I'm a little astounded that staff can't even acknowledge that simple fact. The FMP clearly authorized the replacement of the stick-built dwelling on the 40-acre parcel. There's no doubt in the record. It had no impact on a pre-existing manufactured home on the 10-acre parcel, which is the one we're trying to replace today.
Okay, could I stop you there and go back to Ms. House real quick? Because I want to make sure I'm on the same page with that one. So what I'm going to ask her is the FMP was part and parcel of a replacement dwelling on the 40-acre parcel. Is that a true statement, or does it need explanation?
I don't find that information in the county records. I'm not disputing what they're stating is in the assessor records, but the FMP does not reference that the dwelling that's being requested as part of that land use application is a replacement dwelling. I've not seen that in the record. But again, if there's an open record period, I would, the applicant can point to that information. I just am not aware of that in the record as that FMP being a replacement dwelling approval.
Okay, and before I go back to Mr. Smith and Mr. Campbell, Mr. Campbell went through a list of submitting additional information. I know you haven't had a chance to see it. I'm not trying to put you in a position of responsibility there, but based on what you heard today, are there any informational gaps remaining with respect to the road or the bridge or the irrigation ditch the fire capacity. Are there any informational gaps that you see right now? And if you simply say, I need to check it out, I'll let you know in the open record period, I accept that too.
I mean, there were a lot of issues raised. I
No,
definitely think.
Mr. Campbell, the question was to Ms. House. Ms.
Oh,
House.
sorry.
Do I believe there are information
And
gaps?
still, after what you heard Mr. Campbell testify today.
Mr. Campbell's testimony, I think, was directed a lot to the road standards. So I think that has been addressed. I
Okay,
think that supplemental report, he hasn't handed me everything, so I haven't
sure, I
entered
understand it.
exhibits. So, but I believe he appeared to, his testimony appeared to touch on all those requirements, and the supplemental materials he has here today address those requirements.
Okay, thank you. I appreciate that. Okay, go ahead, Mr. Campbell.
Are you ready for a rebuttal?
I'm ready for whatever you got.
Okay. I'll start and then I'll turn it over to Rand. You know, I recognize that you're asking staff directly if they would. What I interpreted on the open record period is that you're asking staff directly if they would consent to a 14-14-7 with the clock not being told. I think they dodged the issue, but I think they were basically saying no. So I will put forward that we are supportive of two options. Option number one, we still think that you, as a hearing officer, can grant the 14-14 7-day open record period on your own volition, not on our request, so it doesn't toll the clock. If that's not something that you're willing to do, we of course then ask for a 777, a traditional open record period, and we will preserve our objections and take it up in due course. So those are, I mean, we clearly need an opportunity to respond to even some of the arguments that were raised just recently by staff. And so we still think that not tolling the clock corrects that period. I recognize more than anybody else, I'm very well aware of the difficulty if an appeal is filed of getting a quick decision from the county commissioners. But I think that's where staff has put this application. That's on staff to work it out. They can certainly move mountains and get the county commissioners to decide something quickly if an appeal is filed. That would be the better resolution here than causing our client more harm by delaying these proceedings. So that's our preference would be a 14-14-7 that doesn't toll the clock. But if if that's not, if you don't agree to that, then we of course then request that the record be left open, and we'll preserve our procedural objection to raise in another point. I think Ms. Marshall completely understood my first procedural objection. I never suggested that meant that the criteria that staff waited until the staff report to raise were waived. I was saying that staff shouldn't be the one to continue arguing those points. In case law is clear, staff is a party to these proceedings, and they should be barred from raising those additional issues. But I'll say they are continuing to object and to raise those issues. So, the harm is being continued even in staff's most recent assessment. Again, if the hearing officer disagrees, it's fine. Our objections have been noted for the record, and we'll proceed from there. I still think there's a burden shift going on, but I'll answer it as simply as I can. Yes, our client has the burden of proving that the manufactured home on the 10 acres was lawfully established. We have met that burden because we demonstrated that it was that the county issued building permits for the placement of that manufactured home in the 1970s. Period. End of story. The 1983 F&P has nothing to do with proving that the manufactured home was lawfully established on the 10-acre parcel. I mean, it's as simple as that. We will happily, I mean, it's already in the record, but, assuming there's some level of an open record period, we will happily then recall out, make it as abundantly clear as we can, the historical record on the adjacent 40-acre parcel. There is no question that the 1983 F&P then led to our client pulling building permits to build a home on the 40-acre parcel. There was absolutely no change to the dwelling on the 10-acre parcel following from the F&P. So like hiding behind, the F&P doesn't specify which house or any of those kinds of things, just look to the historical record. There's no doubt that the F&P, I mean, county staff is complaining that the site plans were inaccurate. Well, the site plan that they're complaining was inaccurate shows the new dwelling on the 40-acre parcel. I mean, there's absolutely no doubt that the FMP then authorized our client to build a house on the 40-acre parcel as of right. So to the extent there's any ambiguity in that fact, we can point to issue after issue after, or document after document after document in the record that shows that the FMP then led to rebuilding a stick-built dwelling on the 40-acre parcel. It did not impact the legality of the manufactured home on the 10-acre parcel, which is the one we're seeking to replace today. We'll turn it over to Rand.
Yeah. Yeah, do you have any other questions for me, Mr.
No, sir.
Frank?
No, sir.
Okay, one second. Like proving the mobile home's the same mobile home. Issue hasn't.
Yeah.
Okay. Yeah, then I guess one last thing, we haven't really talked about this issue and it seems to be put to rest, but there were some issues raised about potentially the mobile home or the manufactured home that's on the property, the subject property now was somehow removed, or it isn't the same one that was there in 1979 when it was approved. So we went to some lengths to gather information showing that that dwelling is the same dwelling that's been there since Mr. Stroemple purchased the property, and so I'll submit these. But there's a title for that vehicle and it has a VIN number, and then we've got a picture that Daniel recently took of the VIN number on the manufactured home, so those match, showing it's the same. Then we've got a escrow instructions talking about the fact that there's a mobile home on the property. And then another escrow document talking about the mobile home title and the bill of sale. And then this one is a letter. It's in handwriting, but it's from Jess Edgington, who sold the property to George Stroemple back in 1983, and it says it's talking about insurance because when George bought the property, he bought it on a land sale contract, and Mr. Edgington wanted him to carry certain insurance, and this letter says $50,000 of coverage on the house, $5,000 of coverage on the mobile home. Anyway, these things are just to prove that both of them were there in 1979 when Mr. Stroemple purchased the property, and to show that that same manufactured home is still there. So submit those.
Yeah, again, just to wrap up on that particular issue, I mean, this is just bolstering the evidence that's already in the record that the manufactured home was placed on the 10-acre parcel in 1970 by the previous property owner. Our client purchased the land and the personal property, i.e. the manufactured home, and it's the exact same manufactured home that is on the property today that we're seeking to replace. Just the final concluding remarks, all the conditions, I mean, there are a couple issues where we're still recommending conditions of approval. I think we've shown that those conditions are all feasible. Again, the unrelated 1983 FMP must be respected, is both validly issued and not violated. The county has not followed the requisite procedures to argue otherwise, and has not carried its burden to argue otherwise. All other evidence that we submitted into the record today constitutes substantial evidence addressing all of the remaining issues that can't be addressed with conditions of approval. And therefore, this application should be approved. There is no legal basis to not approve it.
Okay, thank you, sir. Anything else from the applicant?
Nothing.
Anything from the staff?
No.
All right. Here's what I'm going to do. I'm going to this is the old split the baby in half. Probably neither side lives, but we'll see how that works. I'm going to grant a 14, 7, and 7 And then in order to make up for that, I will make every attempt to have my decision out within 14 days, which if you add up the days, that means that it's equivalent to a 777, which roughly is what the county has as its standard open record period. So I think I've addressed the timing issue. Ms. House, when at the end, I'm going to ask you for the logistics and the timing, but the way I look at it is 6th is first 7 days, the 14th day would be the 13th, rebuttal 20th, and responsive evidence 20th, and final rebuttal or argument would be on the 27th. I think I got my dates right, but I'm never confident on math or dates. So that's the way I look at the timing. I'll have you talk about that shortly. So let me talk about what I expect from anyone who wishes, desire to submit evidence or argument. Mr. Smith talked about at quite some length about the terminology issue regarding lots and parcels and tracts and whatever. I would welcome clarification from anyone on that issue as it relates specifically to this case, not just a general treatise, but just as it relates specifically to this case. And if you decide you don't want to do that, no problem. As far as the Central Oregon Land Watch impact analysis, from what I understand, the staff was requesting perhaps some additional analysis, at least with respect to adjoining properties. If that is the case, then I would be hopeful that staff responds that, or more importantly, applicant provides that analysis just to ensure that 1840-060 is met with respect to the impact analysis. It seems to me the bridge issue is pretty much taken care of. The collateral attack, I am inclined at this point in time to agree with the applicant that generally speaking, going back and looking at any approval for the 10-acre parcel would be a collateral attack. I also am inclined, but this is where staff has every right to disagree with me, that the approval of the original dwelling and the issuance of the building permits is in fact, and since it's not appealed or wasn't appealed, is a final decision, and in fact that establishes that it was lawful at the time. But if staff, including Ms. Marshall, if you want to disagree with that, I'm open to discussion on that. With respect to Mr. Smith's first procedural argument, as stated by Ms. House and Ms. Marshall, first impression for me, I've never heard that incomplete letter was a contract that limited what staff was allowed to say, argue, or allege. I just don't think staff is restricted in any way, shape, or form by the incomplete letter. But certainly, Mr. Smith, you have the right to disagree with that. As far as due process issue, first of all, as both or all the lawyers are involved, in this case are aware that there has to be some kind of prejudice to the applicant. The applicant has had every opportunity in this hearing to present their arguments to me. Maybe they're not as complete as you'd like, but I don't think that's the legal standard. You're also being given a 14-day, which is an additional 7 days beyond what the county normally would allow. I'm granting that. I am not tolling the applicant. I'm not tolling the time clock on that. So I don't see where you're prejudiced, and I think if you look deep down, you'd agree that that procedural argument just isn't going to go anywhere. So those are sort of my comments, and the reason I mentioned those comments is that I'm hoping that if you disagree with me, and that you let me know in writing. Ms. House, I'm going to ask you to talk about the process and procedure of submitting information into the record with my modified dates.
And so I just want to go on the record to clarify what time or what days during the open record period will not count towards the 150-day clock, and what days will count. So
Final argument never counts against the clock. So I'm simply saying on my own motion, none of the days are going to count against the clock.
Okay. I thought for some reason that final 7, the applicant's final legal argument does not count towards the clock, and the first 14 and then the following 7 would count towards the clock. Am I misunderstanding?
Let me with that go back to Mr. Smith and have him clarify his request, and I'm willing to modify that. I appreciate your comment. Okay, Mr. Smith.
I'm understanding that you're approving a 777 and noting that those 21 days that the clock will be.
That's not what I'm approving. That is not what I
777.
said. I said 14, 7, and 7. 14, 7, and 7.
14.
And now that I think about it, and having you sitting in front of me, what I'm going to do is, since you in the alternative requested the 777, I'm going to count. I'm going to basically use those first 2 as waivers of the time clock, tolling the time clock. And so, in other words, none of it tolls the time clock. Or yeah, let's see. I always get this backwards. Let's see.
Yeah, I'm confused on where we're ending up.
Okay. Tell me what you believe if you got the 777, what the time clock do? What would be the impact on the time clock if in fact I'd granted the 77 as you requested in the alternative?
Well, if the applicant is requesting or consenting to an open record period, then it tolls the clock.
Okay. So you're consenting to the 777, which was the alternative, correct?
In the alternative, if you're not granting our initial request.
I'm not granting their initial request.
All right, well then it's not a waiver, and we'll preserve our procedural objections.
So you don't want the alternative 777. If what you're doing is pushing me, you indicated that you felt constrained and pushed. I'm telling you that I'm just giving you an additional 7 days for the initial open record period. I'm not giving you your second 7 days for the open record period. So I want to know what happens to the clock and my proposal.
So you're willing to give us an extra week with a clock running, but then 777 from there, you're saying we're tolling the clock.
I'm asking you.
We're good with that.
Okay. So phrase it so that it talks about
if we're given 14 days in the open record period, 7 days the clock is running, but then the next 3-week period, if 7 day, if we do 1477 and the clock runs for only 7 of those days, we'll agree to that. I think that addresses our procedural issues.
7 or 14, because the response period, the clock's running as well, or not?
If you give us 7 extra days to respond, and the clock is running during those 7 days, then that is sufficient to address our procedural objection.
Miss,
And so that gives us 7 days because of the procedural objection, and then another 7 days on top of it, which is pursuant to our request.
Okay.
Well, actually, I'll even change it. Look, we can respond to staff's incomplete letter, or excuse me, we can respond fully to staff's report. I hear what you're saying. We were provided the opportunity to come and present our case today. The only thing we haven't been provided the opportunity to do is provide something in writing. So we're fine with a 777. We don't need 14. We're fine with 777, but I would urge you to have the clock run for 7 of those days, and then we'll toll the clock for the other 14. If that's a reasonable outcome, then I think that will address our procedural objections just fine.
Ms. House, Ms. Marshall, whoever on staff side?
I just want to restate to make sure I understand.
No, I appreciate that.
So if I understand Mr. Smith's latest request is that he is the 777 are standard open record period, standard being if the applicant requests it. You're supportive of that and that time not counting towards the 150?
No, I'm saying we get 7 days with the clock running, and the clock will be told for the other 14.
Okay.
But I think, look, we're going to continue banging this drum that like, I understand what you're saying, that the incomplete letter is not a contract, but I disagree. I think we've absolutely, I think there's been some gamesmanship with the process here. And I think state law and county code is crystal clear that the staff is supposed to raise in the incomplete letter all of the missing, or to know all of the missing information. And that absolutely did not occur in this case.
Okay.
So yeah, we initially asked for 14.7. I hear you. I hear you, Mr. Frank, that you're not going to grant that. But I think our objection will be satisfied if we have the clock run for just 7 days and then it's told for 14. And we just do a 777, but the clock runs for 7 days. I think that's a fair outcome under the circumstances.
So we're not, the 1477 is off the table.
We don't
You don't
need
need it.
a week. Yeah, we don't. More time would be nice, but I hear, I took to heart your comments, and I'm trying to be flexible on behalf of our client. And
Okay.
we want this to move as quickly as possible. So I'm not trying to jam up the county. I think even under our request, they're presuming that there's going to be an appeal filed and some of these other kind of things. I think we can all cross that bridge when we come to it. And so we just want this application quickly moving. And so to do our part, we're happy to provide additional written argument to all the points you just raised in the next 7 days. And if the clock is running for those 7 days because you, hearing officer, are the one who's tolling the clock, then I appreciate that. And in exchange, we will consent to the clock being told then for the last 2 periods. Is that
now I'm
we all on
even
the
more
same page? Is that fair?
last 2 periods. The last period is the final argument, and it would have never run. It would have never been told then.
I think there's
Clock
I've
doesn't
seen it
count.
on multiple different ways. Yeah, there's inconsistency all over the state on what to do with the final legal argument. But again, what I do know is that we can submit our final legal argument early, and then the clock's ticking again. I mean, there's no doubt about that. So,
Well, if you submit it
that
early,
again,
I
think
start
is
my
within our-
decision early, and it gives you a greater opportunity to get in front of county commission if that, in fact, is your goal. I'm not saying it is. I'm just saying if that's the goal. So,
yeah.
Okay. All right. So it's going to be 777 on my direction. The clock will only run for 7 of those days. Ms. House, is that clear enough, or do I need to explain myself further?
No, I think just the clarification that 7 of the 21 days will count towards the clock is enough. We don't have to worry about anything
Yes.
beyond.
Yeah, that's said a lot clearer than I did. All right. You want to talk about the logistics and the dates?
Yeah, so give me a second to share.
So they
my
should be consistent pretty much with your slides.
Yeah, well, I had updated them and I just updated them. But, okay, so for new evidence and testimony, the deadline for submittals will be Thursday, March 6th at 4 p.m. Rebuttal evidence and testimony, the deadline will be Thursday, March 13th at 4 p.m. And the applicant only has an opportunity to submit final arguments on March, or no later than March 20th at 4 p.m. And it's important to note that electronic submittals must be received by the county server by 4 p.m. on the date of the deadline. And Rand Mr. Campbell, just, the PowerPoint you submitted, I didn't receive that till 1:05. So that's the kind of delay in our server on large files. So just kind of keep that in mind on your timing if you're submitting large files electronically. And all submittals should be sent to my attention. They will be entered into the record, and obviously the hearings officer will be reviewing everything in the record. And electronic submittals should be submitted to my email, which is caroline.house@deschutes.org. And it's really important that you don't include any links or links to a cloud storage system, because we can't retrieve those securely. So go ahead and attach everything as a PDF or similar file type. And as I mentioned before, 4 p.m. is the deadline for electronic submittals. And that's everything I needed to cover.
Okay, thank you. Mr. Smith, Mr. Campbell, any questions?
No questions.
Okay, thank you. I appreciate the testimony. I appreciate your input in this case. I think I've made myself marginally clear about the things that are concerning me about this case. I have to admit, when I first looked at the application or the request for a hearing date, it said a replacement forest dwelling. I thought, well, this will be over in 20 minutes. That was my first mistake. This is a little bit more convoluted than I originally thought. But as in every single land use case, the more input you give me, the more likely it is that I have a quality decision when it comes out. And so I look forward to receiving the information on the 6th. The 13th and the 20th. And keep in mind, for anyone who would be listening to this or reviewing this video, that if in fact you intend to submit something into the record, open record up until the 6th is for everyone. Response should be in response to what was submitted in that first period, and only the applicant has the right for final argument during that final period. Those are the rules, and I tend to abide by those rules pretty strictly. So with that, I thank all of you for your participation. We will close the hearing at this time. Thank you.